that I still believe sometimes you should change the law to deal with economic realities, but the enforcement of the law as it is a critical ingredient to the rule of law and to the willingness of society to make change, because they have to have confidence that whatever society decides will in fact be what is executed by the public officials.
Thank you, Secretary Chertoff, for your commentary. I don't know if you'll comment on recent Supreme Court cases at all, but how much of a threat, if any, do you think to Homeland Security the Supreme Court's most recent decision in the Guantanamo Bay case has caused?
This relates to the Boumediene case, which has to do with Supreme Court decision overturning a congressional statute that set a certain procedure for reviewing the cases in Guantanamo. And for those not intimately involved in the details, and I should say it's not really my department, it's the Department of Justice, but I'm familiar enough to be able to give you a high-level view. Congress passed a law a couple of years ago that basically said if you are a detainee that's been captured in Afghanistan or elsewhere and you're in Guantanamo, and there's a process in place for the military to determine whether in fact you are dangerous, whether you are in fact someone who's an enemy combatant, that you get a review of that in the United States Court of Appeals for the D.C. Circuit, which is the federal court in Washington, and then from there to the Supreme Court. Some of the detainees' lawyers filed the case basically saying that they didn't want to wait until the D.C. Circuit reviewed it. They wanted to have an immediate right to go into a federal district court and challenge these detentions. And the Supreme Court said, notwithstanding that Congress had chosen this path, they invalidated the statute and said there has to be an immediate recourse to district court. I might say, just to put it in context, and I was a judge, a Court of Appeals judge for a couple of years, it's very customary in our system to say to people who are aggrieved, including people who are in prison, you have a right to review, but you have to proceed in a certain way. You've got to start here, you've got to take your appeal in a certain route. You don't have a right to jump around the system. So this was a little bit of an exceptional thing for the Supreme Court to do, and it's particularly exceptional because it's comparatively rare to invalidate a statute. What's the consequence of this? Well, it raises the question, now that the district courts have been given this power, what is the standard that they're going to use? What is considered to be sufficient evidence? What, in fact, is the legal standard that you need to hold somebody? These are usually matters that Congress sets out, and then the court decides whether a particular case meets the standard. Attorney General Mukasey recently spoke out about the need now, in light of the decision, for Congress to get about the business of writing a set of standards down so that the courts have guidance. I think it's of urgent importance for Congress to do this. Otherwise, you're basically forcing the courts to kind of make it up as they go along, and it puts the judges in a bad position. It puts the country in a bad position. It would be a bad thing if a dangerous person were released. We've seen that happen. A person was released, they went back to Kuwait, and then the next time we encountered them was when they blew themselves up in Iraq and killed a number of people. It would be worse yet if some of these people were released into the United States because their home countries wouldn't take them back, and we would be in the very unhappy position of having people in the United States who were dangerous and simply allowed to move around freely because we would be prohibited from holding them. This is a complicated issue. I do think what it requires is for Congress in the very near future to really sit down in a bipartisan way and figure out how do you balance, you want to be fair, you want to have a fair process, but you also want to recognize that if you make a wrong decision and let somebody out, there are potentially very, very serious consequences.
Hello. I want to ask you about, you were a prosecutor in New Jersey, but I want to ask you about your role as defense attorney for Dr. Magdi El-Amir, who had been accused of embezzling millions of dollars and supposedly had links to Al-Qaeda and funding Al-Qaeda. And also a consular officer named Michael Springman talked about a visa fast-track program that was implemented in Saudi Arabia that put through people who wanted visas to come to the United States over and above his objections. So please.
This is a tribute to the wonders of the internet, which exhume all kinds of information and, frankly, a good deal of misinformation. As to the latter, I don't know who Mr. Springer is. I'm not quite sure what his accusation is, so I'm not going to guess at it. As to the former's, that's slightly inaccurate. I was actually a defense attorney. I did spend time after I was a prosecutor as a criminal defense attorney, so I actually do believe in both sides of the process. I'm sorry to disappoint, but it was kind of a pretty garden variety case involving accusations of healthcare fraud. And I know that because the individual in question was, I think, originally Egyptian, the blogosphere got all of Twitter at some point about finding some remote connection somehow to terrorism, but actually there was no issue of terrorism in that case. It was just a kind of plain old garden variety, plain vanilla accusation of billing fraud with respect to Medicaid. And actually, I think I left before the case was resolved, and that's what lawyers do.
Secretary Chertoff, you mentioned the importance of having security measures. My question has to do with what is your agency doing when these security measures have unintended consequences? Specifically, what is the agency doing when someone's name gets on a watch list or a no-fly list, and that person's name is inappropriately put there? We've all heard incidents of 5-year-old children, federal judges, and at this point in time, it seems that once that name is on there, there is no way of removing it. They seem to be there for years. What is being done about this?
There are two aspects to that issue. First, let me say that some of the numbers of people thought to be on these watch lists are much exaggerated. I think that the total number of no-flies is, in the range of, thousands, not hundreds of thousands. And even selectees who are allowed to fly, but up until recently have not been able to get their boarding pass directly, is a very low in the 100,000 range. The two problems are this. The less frequent problem is the person who is genuinely on the list and they think they shouldn't be. And, that's a challenge with balancing the fact that you've got to decide how to balance the risk. Most people who are selectees, the downside risk to them is some inconvenience. And in fact, we're doing some things which I'll explain in a minute to reduce the inconvenience. The downside risk to if we don't have the system is the possibility of a dangerous person getting on a plane. The no-fly list is a tougher one because that actually prevents a person from flying. There are comparatively few Americans on that list. A lot of them are foreigners. And you would not expect us to allow Osama bin Laden to get on an airplane or senior al-Qaeda official or someone who we know has been involved in plotting to get on an airplane. So we do obviously have to preserve that list in order to protect ourselves. By far the more frequent problem you get is the false positive problem. And that's the case where a name gets on a list, like, and I'll just say John Smith, for example, and there's a lot of John Smiths. And the question is, how do you separate the real John Smith that you want to have on the list from all the John Smiths that you don't care about? That's an identity issue, by the way. Here's what our solution is. Our solution is that, and we've told the airlines, expressly told them that we want them to do this. If a person who comes up as a selectee a lot, because of this name confusion issue, gives the date of birth to the airline, then the airline can input that into their system, their reservation system, or they can assign a number through a frequent flyer system. And then they are free, when that person checks in and puts in their date of birth or puts in their frequent flyer number, they're free to treat that person as not being a selectee. In other words, we use the additional data element to remove the person from being associated with the bad John Smith. Some airlines are doing that, and therefore it is our hope that in the very near future, anybody who was on the list before is going to be able to get their ticket in a kiosk or at home like everybody else will, because by putting in their Social Security, their date of birth or their frequent flyer number, the airline database will know that they are not the John Smith we're worried about, and they'll be able to treat them like everybody else.